Ladies and gentlemen of the council, I'm sorry?
Good evening.
Good evening, thank you. Ladies and gentlemen of the council, I'm here tonight to call attention to events that are occurring which may be detrimental to the well-being of our city. Despite the plethora of information provided to the Warren Police Department on 2 separate occasions within the last few months, citizens of this city have had their rights violated by more law enforcement officers. Each case involved incidents of officers responding to calls about citizens with an openly carried firearm, which is legal in the state of Michigan. It is imperative to note that the data obtained through the Freedom of Information Act showed no reports of any criminal activity by the individuals or in the vicinity of the individuals at the time of their incidents. This fact is important because without suspicion of criminal activity, there is no lawful purpose to detain a citizen. In each of these cases, the citizens were illegally detained, searched in violation of their Fourth Amendments. On July 18th at 2009, 11 a.m., a citizen was legally open carrying while shopping in Warren. This citizen was unlawfully detained without reasonable suspicion or probable cause. The officers unlawfully seized his wallet and firearm, violating again the Fourth Amendment rights against unreasonable search and seizure. Per Michigan's concealed pistol law, a concealed pistol license holder is only required to immediately disclose when they are concealing a pistol, not when it is in plain view. The officers proceeded to lecture and berate the citizen, falsely stating that he was required to disclose. After a long, unnecessary detainment, the citizen was issued an unlawful citation for failure to notify an officer of CPO license. The citizen went to court to defend himself without representation pertaining to the citation. The case was immediately dismissed. Provided some briefs with some more information. Our state constitution, in addition to our national constitution, specifically acknowledge the inalienable right of every man and woman to bear arms and protect themselves, also from illegal searches and seizures. These, along with several Supreme Court decisions, were violated and or ignored. The fundamental right to keep and bear arms has been wholeheartedly acknowledged by Michigan legislators, so much so that in 1990 they enacted legislation ensuring that no local unit of government within the state would be able to restrict this right. While I support and greatly appreciate the police officers of Warren as a whole, sad to say that the Warren Police Commissioner has been allowing the department to freely and openly violate the rights of the very citizens he is sworn to serve and protect, simply because they choose to exercise this right. Several citizens have attempted to resolve this matter by requesting private conversations with the Commissioner. However, the Commissioner has, to date, disregarded these requests. The next option was to bring this matter to the City Council's attention so that the city may be held accountable to the public. There's another point of equal importance that needs to be made tonight. As mentioned, local government is prohibited from restricting the possession of firearms of the citizenry. Despite this, the city still maintains such illegal restrictions as specified in the Warren Code of Ordinances, Part 2, Chapter 22, Article 7, Division 2, Sections 22-165, 22-166, 22-167, and 22-168. These regulations are misleading to the public, and they give conflicting directions to law enforcement. This council should be cautioned that, having now been informed, failure to bring these ordinances into compliance with state law could be construed as an act of malfeasance. Furthermore, should a citizen have their rights violated due to these ordinances, the city and its taxpayers would likely find themselves in an embarrassing and costly situation defending an illegal action. In closing, as a taxpayer citizen of this great city, I urge the council to immediately seek legal guidance from the city attorney regarding these matters and put a stop to the violation of its citizens' rights before the city and taxpayers find themselves facing legal and financial repercussions. This is a notice to the council, and we expect no further issues. Thank you for your time.
Thank you very much. Our next speaker is John Kunith.
Good evening, Council. -165, carrying loaded firearm. 2, Article 7, Division 2, Section 22 through 166, carrying concealed weapon, and Article 7, Division 2, Section 22 through 167 of the City of Warren Code Ordinance.
Mr. Stevens, I'm sorry. Can we get a motion and support?
Motion to approve.
I don't quite know what the motion is for, but can you say real quick what the motion
To repeal.
to repeal it? Thank you. Okay, motion by Mr. Sadowski, support by Mr. Stevens. Discussion, Mr. Stevens.
Thank you very much. This is an item. Actually, this has been happening around the state, where a number of communities have ordinances, and the state law supersedes it And in fact, our city attorney on August 11th gave us a letter to the effect of this, and so this is a follow-up on it, that these city ordinances, well, at least one, and then portions of 2266 and 2267, because of what they contain, make them non-enforceable and without merit, so to speak. And so what I've done is requested the repeal of these because state law supersedes them. Most specifically, MCL 123.1102, which basically, in essence, it says the cities cannot regulate firearms except as otherwise provided by federal or state laws. And that's the reason for my request for repeal on this.
Thank you. Any other comments from council members? Seeing or hearing none,
Madam
I'm sorry, Ms. Vogt.
Madam Chair, we're abrogating? It says abrogation of. What does that mean?
Repeal.
Abrogation means repeal?
Yeah. If you look up repeal in the dictionary, it'll say to abrogate.
No.
Abrogation.
And so we just want to do away with these.
Repeal, yes.
Madam President,
Mr. Richards?
what Councilman Stevens has just indicated is pretty much correct. I did send you a letter in August on this general topic. The first section referred to 22-165, I'm convinced is unenforceable without any further review. The other parts, section 22-166 and 22-167, at least in part, are not enforceable. There are parts that maybe are enforceable under the current law. I'm not clear whether the motion is to repeal everything tonight or if it's to refer it to our office to review and indicate specifically what portions are preempted by MCL 123.1102, or is the intention that they be repealed immediately. It would be my recommendation and suggestion that it be referred to our office. I can tell you I already know the answer on one of the sections. The other two, it's probably going to be a portion is no longer enforceable and a portion of it may be enforceable. But I would appreciate if I have that clarification one way or another.
Mr. Stevens?
Thank you, Madam Chair. Yes, the intention was to repeal all three sections, and because there are, the way they're written, there are portions of them that are non-enforceable, which makes the whole section unenforceable. If somebody wanted to, I guess, amend them, but they are covered by all three of those items are covered by state law. So to have them in the city ordinance is repetitive and not necessary.
Any other discussion?
Madam Chair,
Ms. Vogt?
if we were referring this to the city attorney, for the city attorney to do, as he said, go through it, let us know which ones are not excuse me, enforceable and which portions are, I'd feel more comfortable with this, rather than just wiping it off the books without knowing what is or isn't enforceable.
Any further discussion from council members? Motion stands. Go ahead and call the question. Mr. Sadowski?
Yes.
Mr. Stevens?
Yes.
Ms. Vogt?
No.
Mr. Warner?
Yes.
Mr. Bacamino?
Yes.
Ms. Comartin?
No.
Mr. Green?
No.
Mr. Liss?
No.
Camp, yes. The item passed 5-4.
Item 16B, Council Vice President Donna Kazar-Comartin, discussion